The complaint under the 2020 regulations needed to be a formal complaint signed and written by the complainant themselves, the Title IX coordinator, or in the case of K through 12 students, it could have been their parent or guardian. This has been relaxed, and now it doesn't need to be signed anymore. It can be any written or oral request to initiate a grievance procedure. In terms of sex-based harassment claims, it's pretty much the same individuals who can make complaints now as under the 2020 regulations. They tweaked the definition a little bit where it's parents, guardians, or any other legal representative for those K through 12 students, but essentially the same people are making those complaints. The big change here is for sex discrimination claims. So under sex discrimination claims, any third party participating in the school's program or activity when discrimination occurred can file a complaint, even if they are not in any way affected or even benefited from that discrimination. For example, if you have two students apply for a prestigious research position in a lab on campus, the female student much better qualified, but the male student gets the position. The first day in the lab, the professor that hired him says, that other candidate was great, but I didn't want a woman working in the lab. Clearly, that female student was discriminated against because of her sex. Even though that male student has benefited from that, he can file a complaint alleging sex discrimination for that refusal to hire her because of her sex. This can kind of lead to things getting out of hand. Sometimes some people who are victims or have been discriminated against don't want to file complaints themselves. This is taking away some agency for the person who is actually affected to decide for themselves what they want done. So this could be an issue in the future where maybe you have a runaway train situation where someone filed a complaint, the school starts investigating it, and before anyone can stop it, it's already underway. But I think the DOE sees that as not really an issue. They think that complaints are being underreported. So with this, plus the mandatory reporters, I think they're going to view it as a net positive that all these extra complaints are being filed because, in their view, too many things are going unreported. For supportive measures, this is a fairly large change, even though the language isn't necessarily that different. The supportive measures still need to be non-disciplinary and non-punitive. And under the 2020 regulations, the burden could technically be placed on the respondent, but in practice, everyone's understanding was anything more than a mutual no-contact order was too much of a burden to be placing on the respondent because they're presumed innocent, and often schools will have a list of 20 sanctions, and if you impose one of those sanctions as a supportive measure, you're disciplining the student before any finding responsibility. The Department of Education is saying, well, we're clarifying the rule. You actually always could have been putting the burden on respondents. They're making it much more explicit now that you can do that. And just because something is on the list of possible sanctions does not mean that you can't impose it during the supportive measure, as a supportive measure during the pending grievance process. The respondent may challenge any burdensome supportive measure before it goes into effect. But this is going to be a big shift because essentially most, if not all, schools are going to start putting the burden on respondents in these cases, even though on the one hand they'll be punishing the student, but on the other hand they'll be saying, don't worry, you're presumed innocent. You just can't go to class anymore. So we'll see how that goes. But hopefully they are urged to consider the least burdensome supportive measure, so hopefully it doesn't get out of hand. Next is the jurisdiction. So under the 2020 regulations, the jurisdiction for Title IX was really narrowed quite a lot. Study abroad programs were no longer covered, and if misconduct occurred off campus, even if it involved two students, a lot of the time that was not going to fall under the Title IX regulations, and the school was forced to dismiss it unless it was at a fraternity house off campus maybe. This was criticized heavily, I think, by both sides. victims advocate side, the complaint was you're letting all this misconduct go unchecked, and attorneys who were representing respondents felt hard done by because the school would dismiss the case under the Title IX regulations and then just bring it under a parallel process where the student had no rights to review the evidence, cross-examine witnesses. So really nobody was happy with how that was being handled. Under the proposed regulations, the Department of Education is going to reopen it to apply to American students who are in American study abroad programs. Just because you're out of the country doesn't mean Title IX is not going to apply to you anymore. They're also expanding it where if the school has jurisdiction over the students, just because it happened off campus doesn't mean Title IX is not going to apply. So you're going to have a lot more cases being adjudicated under the Title IX grievance procedures than you had in the past. Even if maybe there's not more complaints being filed, it's just they're going to be funneled through the Title IX process now. And finally, students who, in the past, if you had graduated, you weren't able to, you would struggle to get the school to take up your complaint, again, because you were no longer actively participating or trying to participate in the program. That's, as Kimberly stated, that's no longer the case. Even students who are just there for a day or two to participate in athletics can now file complaints, and the jurisdiction will expand to those individuals, even though they're not students. Even prospective students can file complaints, depending on the circumstances.